Dear friends, I Nisha Gupta, myself CS Megha Goel, welcomes to you all on behalf of the Board of Studies, the Institute of Chartered Accountants of India on today's session. Dear friends, today's session has been scheduled with respect to paper 2 of your intermediate course, that is Business Laws, Ethics and Communication. In this session, we shall be discussing on chapter 1, which deals with the Indian Contract Act 1872. This chapter comprises of 9 units, whereby we shall be discussing on the general principles related to the formation of the contract, besides with the special contracts and what are the rules for their enforcement. As you all know, that contract is a commonly known legal concept in our society, and it is in common and essence to the political, economic and social life. The contract can be interchangeably used with the terms agreements, deals, undertaking, and so on. The Indian Contract Act is being regulated by the, you can say the laws of contract is in fact regulated by the Indian Contract Act 1872. It came into an enforcement on 1st September 1872. It is being applicable to all over India except the state of Jammu and Kashmir. So now with this brief introduction on the subject, move to the presentation. Please go through the following disclaimer. Students, you are being provided with the facility of learning management system where you can simply go on by logging your registration number, which is freely accessible, and the facilities related to all the subjects related to the e-lectures are available on this portal. So you students are advised to refer the study material, including supplementary study material, if any, with related to any of the subject, along with the latest relevant legislation required for the forthcoming examination. So let's start up with the session. First, the meaning of the contract. If you go with the term contract, the contract has been defined under the Act as an agreement which is enforceable by law. So you can find here there are two essential elements in a contract. First, an agreement, and second, an enforceability by law. So when you talk about a contract, you come to see a new term, an agreement. So it is required that you should know the meaning of the agreement. The term agreement has been defined in the Act under Section 2E of the Contract Act. So according to the definition, agreement has been defined as every promise and every set of promises forming consideration for each other. That means we can understand this concept with the help of an example. Suppose if A is a person who promises to sell his car to B, and B in return promises to pay for the same. So here you can see there is a consideration between A and B, mutual consideration. That means A promised to sell his car in lieu of the payment made by the B. So this leads to an agreement, because as already I have told you the definition of the agreement, that every promise and every set of promises forming consideration for each other leads to an agreement. And once this agreement is supported by and enforceable by law, that means it is legally enforceable. It's giving a legal binding to the terms and conditions of the agreement. This may lead to the formation of contract. Further, let's see how you can understand the concepts of the contract. First, you see the person is required to signify. First, a person is required to make a proposal, whereby what he does, he offers to the person to agree on any of the condition or terms of any of the offer. And second, the person signifies his assent, then such a proposal is accepted. And when a proposal is accepted, it makes a promise. And when the promise is supported by a consideration, it leads to the formation of agreement. And once an agreement is being formed, you will find there are further this has been divided into two parts. When an agreement is legally enforceable, then it may further lead to contract, that is, which means legally fully enforceable, and the other one is voidable, which is enforceable at the option of one or other parties. And the second one, the legally not enforceable agreement, it shall lead to a void agreement. This is how you can understand the concept from the offer to the formation of the contract. Moving next to the types of contract. So here you can find that the contract has been divided on the basis of three things. First, on the basis of validity, then on basis of formation, and on the basis of performance. On the basis of validity, you find there are the various types of the contract: valid, void, voidable, illegal, and unenforceable. Whereas on the basis of the formation, you will find these three types of the contract given under the heading formation. Whereas under the performance, you will find the other four types of the contract, which depends on the formation of the contract, how you have performed the contract. On the basis of that, there are four types of the contracts. So we can understand this thing with an example. Suppose if Mr. X agrees to write a book with a publisher. After few days, X dies in an accident. Here the contract becomes void due to impossibility of performance of the contract. So void contract because it cannot be enforced because the person who agrees to write a book has been dead in an accident. So this leads to void. Similarly, we can take one more example. A delivers goods by mistake at the warehouse of B instead of that of C. Here, B, not being entitled to receive the goods, is obliged to return the goods to A, although there was no such contract to that effect. That means this is, we can see an example of implied contract. Implied contract created by law. Similarly, when you take a ride on the bus, and as you take a seat on the bus and you pay the fare, that means you have entered into an implied contract that the bus will drop you at the required destination. Next, essentials of valid contract. This has been given under Section 10 of the Indian Contract Act 1872. Section 10 clearly defines when any agreement shall be treated as a contract. That means there are certain requirements, essentials, which should be there in the formation of a valid contract. So these are the intention to create legal obligation through offer and acceptance. That means there must be an agreement, that is offer and acceptance, created with an intent to create a legal obligation. Second, that should be made by free consent of the parties. That means it should not be made under compulsion, or that parties has properly given their consent to enter into a contract. Then the parties who are entering into the contract should be competent parties. This is all given under Section 11 and 12 of the Indian Contract Act. Further, there must be lawful consideration and lawful object. That is, with what intent the contract has been made. The purpose, the design of the contract should be lawful, and the consideration given for the contract should also be the lawful one. Then next, the agreement not expressly declared to be void. There are some contracts or agreements which has been expressly declared under the Act as void. So such an agreement should not have been expressly declared to be void here. If it falls under that category, then that means that is not a valid contract. Then acceptance. When the proposal is said to be accepted, it is an expression by the offeree of his willingness to be bound by the terms of offer For an example, X offers to sell his car to Y for rupees 1 lakh. Y agrees to buy the car for rupees 1 lakh. Y's act is an acceptance of X offer. Now next question is how to make an acceptance and what is the mode of acceptance. There are two types of mode of acceptance, implied acceptance and express acceptance. Implied acceptance is that acceptance which is made otherwise than in words. For example, A enters into a bus for going the destination and takes a seat. That this contract is an implied contract, and express acceptance has been signified either in writing or by word of mouth or by performance of some required act. For example, A loses his dog and announces a reward of rupees 500 to anyone who brings his dog to him. B need not convey his acceptance of journal offer, and here B finds the dog and gives it to A. He is entitled to the reward as he accepted the offer by doing the required act. So this is an express acceptance. Now we will go through that what are the legal rules for a valid acceptance. As per section 7, an acceptance is valid when it is absolute and unqualified and is expressed in some usual and reasonable manner. That is, offer must be accepted as it is without any reservation, variation or condition. For example, if A offers B, will you purchase my dog for rupees 100? And B replies, I shall purchase your dog for rupees 100 provided you purchase my cat for rupees 60. B in such a case would not be said to have accepted the proposal of A. The second rule for a valid acceptance is that it must be communicated to offerer. Acceptance is complete only when it has been communicated to the offerer. A mere mental acceptance is no acceptance in the eyes of law. For example, F offered by letter to buy a nephew's horse, saying, if I hear no more about it, I shall consider the horse mine. The nephew did not reply, but he told an auctioneer not to sell that particular horse as he had sold it to his uncle. By mistake, the auctioneer sold the horse. F sued for conversion. Held, F could not succeed as his nephew had not communicated acceptance and there was no contract. Then third is the mode of acceptance. Where the mode of acceptance is prescribed in the proposal, it must be accepted in that manner. In case no mode is prescribed, then the acceptance must be according to some usual and reasonable mode. For example, if the offerer prescribes acceptance through messenger and offeree sends acceptance by email, there is no acceptance of the offer if the offerer informs the offeree that the acceptance is not according to the mode prescribed. But if the offerer fails to do so, it will be presumed that he has accepted the acceptance and a valid contract will arise. The continuation to legal rules for a valid acceptance. Acceptance must be given within the specified time limit, if any, and if no time is stipulated, acceptance must be given within the reasonable time and before the offer lapses. And acceptance must be made before the offer lapses or is terminated, revoked, or withdrawn.
Now looking to the next rule, when communication of offer is complete. The Act says that the communication and offer is complete when it comes to the knowledge of the person to whom it is made, either by words spoken or written, and or you can say it may be inferred from the conduct of the parties also. So this rule can be understood more clearly with an example. G sent his servant, as already this example has been discussed earlier. Now we shall be taking this example again, which deals with a case law, Lalman versus Goridar, and let's go with the example to understand the conceptual clarity of this rule. G sent his servant to trace his lost nephew. When the servant had left, G announced a reward to anyone who traces the boy. L found the boy and brought him home. When L came to know of the reward, he claimed the reward. It was held that L was not entitled to the reward because he did not know about the offer when he was finding the missing boy. Since there was no knowledge of the offer to the person, and that's why there was no communication of offer, and so no formation of contract is there in this situation. When communication of acceptance is complete, as per the law, it says that as against the proposer when it is put in the course of transmission to the proposer. As well, the communication of acceptance is complete as against the acceptor when it comes to the knowledge of the proposer. Let's understand this concept with the help of example. A agrees to sell a house to B, and B accepts the proposal by letter. So in this situation, communication of the acceptance is complete as against the proposer. This communication will be divided into two parts. First, with respect to A, that is as against A, the communication of acceptance will be complete when letter is posted. Whereas as against B, when letter is received by A. And suppose if A revokes his proposal by telegram, here the revocation will be complete. Again, the revocation will be divided into two parts, against A and against B. So revocation will be complete against A when telegram is dispatched, and against B when B receives it. So this is how the communication of acceptance is complete. Similarly, if there is a B want to revoke his acceptance by telegram. So again here we will divide the revocation of acceptance under two headings. First, against B, that is against the acceptor when telegram is dispatched, and against the proposer when it reaches him. So this is the concept with respect to the communication of acceptance and its revocation. This is same as already explained to you. Now, taking the meaning of consideration.
Section 2D of the Indian Contract Act defines the term consideration. It means that when at the desire of the promiser, the promisee or any other person has done or abstained from doing, or does or abstained from doing, or promises to do or abstain from doing something, such an act or abstinence or promise is called consideration for the promise. For example, A promises to maintain B's child, and A promises to pay rupees 1,000 to B. Promise of each party is the consideration for the promise of the other. We can take another example, like A promises to carry B's good free of charge, and B allows A to carry the same. Here B does not offer any consideration to A. Is this a valid contract? The answer to question is B has suffered a detriment or disadvantage while allowing A to carry his good. Here there is a sufficient
Consideration. This illustration is given essentially to prove the point that consideration could not be necessarily a gain or advantage, but it can even be a loss or a detriment to the promise. There is a rule of law that a consideration is an essential element for a contract. If there is no consideration, there is no contract. However, there are some exceptions to it which we will discuss in the coming slides. Now we will look at that what are the essential elements for a consideration. The consideration must move at the desire of the promisor or either promisee or any other person, but it cannot be moved at the desire of the third party. The consideration may be past or present or may be future. Consideration need not necessarily be of the same value as of the promise for which it is exchanged, but it must be something which can be inadequate as well. The consideration must be real and competent, and it shall not be unlawful, immoral, or opposed to public policy. There is a general rule like a stranger to a contract cannot sue. This is also known as doctrine of privity of contract. Thus, a stranger or a third party to an agreement lead to the doctrine of privity of contract. The doctrine says that only parties to a contract can enforce the contract. The party stranger to a contract cannot sue and be sued. For example, a contract by the purchaser of a mortgaged property to pay off mortgagee cannot be enforced by the mortgagee who was not a party to a contract between vendor and the vendee. So here we can see that trust is an exception. Then acknowledgement of liability. In the case of acknowledgement of liability, a third party can sue for benefits. For example, A gives 25,000 to B to be given to C, and B informed C that B is holding it on behalf of C. But subsequently, B refuses to pay C, then C can sue and enforce his claim. Then covenant running with the land, contract by the agent, assignment of a contract, or a family settlement. All these are exceptions where the third party can sue the contract.
As already discussed, that it is a general rule that no consideration, no contract. That means any contract made without consideration is void. This is given under section 25 of the Indian Contract Act. So there are certain exceptions when any contract can be made even without consideration. These are agreements made on account of natural love and affection. So there are certain requirements to fall under this exception. First, that such an agreement must be written and registered. This is the first condition. Second condition, that it should be based on natural love and affection between the parties. Then third is that the parties must be standing in near relation to each other. Then only such an agreement without consideration can be enforced. Next example is with respect to promise to compensate. Here, there are two basic requirements to fall under this exception. First, that a promise to compensate should be a person who has already voluntarily done something for the promisor. Then only such an agreement is enforceable even without consideration. Then promise to pay time-barred debt. Where a promise is in writing, then signed by the person making it or by its authorized agent to pay a debt barred by the limitation, it will be considered as a valid agreement, though it has been made without consideration. Then where there is a gift, that too completed gift, that means proper offer of the gift as well as acceptance and delivery has been done, it may lead to the completed gift, and this will be without consideration and it is enforceable. For the bailment, in the formation of the bailment, no consideration is required as per section 148. Similarly, under the charity, where the promisee undertakes the liability to contribute, such a contract shall be valid, and in the agency, no consideration is required for the creation and such an agreement is valid. Next, who are competent to contract?
The following persons are competent to contract. First, major. Second, sound mind. And third, not other disqualified from contracting. We can take an example like alien enemy during war cannot enter into contract with an Indian subject to certain conditions. Now we will see in the coming slides that what are you mean by major, or what are the persons who are of sound mind and who are the persons who are of unsound mind. The Indian Majority Act 1875 defines majority as every person domiciled in India attains majority on the completion of 18 years of age is a major. And a minor is a person who has not attained the majority. So we will look into the law relating to minors agreement. The law protects minors' right because they are not mature and may not possess the capacity to judge what is good and what is bad for them. So these are the benefits you can say when we make an agreement with a minor. Then first is void agreement. Second, no ratification on attaining majority. When they complete the age of 18, then the contract is not ratified. Beneficiary, no estoppel. In case of supply of necessaries, contract by guardian, minor as a partner, and in case of fraudulent representation of age. In all these, the minors are benefited. For example, X, a minor makes a promissory note in the name of Y. On attaining majority, he makes a new promissory note in place of old one. Neither the original nor the new promissory note is valid. We can take another example where a mortgage was executed in favor of a minor. He can get a degree for the enforcement of the mortgage. Now we will look at who is a person of sound mind. A person who is capable of understanding it and of forming a rational judgment as to its effect upon his interest. It is covered under section 12. For example, the example of persons having unsound mind includes idiots, lunatics, and drunken persons. A sane man who is delirious from fever or who is so drunk that he cannot understand the terms of a contract or form a rational judgment as to its effect on his interest cannot contract while such delirium or drunkenness lasts.
Now coming to the next essential elements of the contract, that is what is consent. That is, any agreement is required to be entered with meeting of minds, that is with free consent, when they agree upon the same thing in the same sense. So it is being said the consent between the two or more persons is said to be have given when they agree upon the same thing in the same sense. And the absence of this consent may lead to the agreement void ab initio. Now taking an example, the defendant had purported to endorse a bill of exchange, which he was told was a guarantee. You can see there was a no consent and consequently no agreement entered into by him, and therefore he was not liable on the bill because he was not having the meeting of a mind. He was thinking that he's endorsing a bill of exchange, and in fact, he was thinking that he's endorsing a bill of exchange, but in fact, he was made to sign a guarantee. So, since there was no meeting of mind, so this does not lead to a contract. Then, what is free consent? Free consent, these are the factors given here, and if any consent is obtained vitiated by any of these factors, it may lead that the contract is not given freely. That means there is no free consent. So for a contract to be valid, it is not only necessary that the parties consent, but also that they consent freely. So where there is a consent but no free consent, there is generally a contract voidable at the option of the party whose consent was not free. Now let's take these different types of the elements vitiating the free consent. The first one is coercion. Coercion is being given under section 15 of the Contract Act, whereby it defines that committing any act which is forbidden by law, or threatening to commit any act which is forbidden by law, where even the threatening it itself an offense, and it will be not considered as a free consent, and then unlawful detaining of any property or threatening to detain any property will be considered as a coercion. So we can take an example. A Hindu widow was forced to adopt X under the threat that her husband's dead body would not be allowed to be removed for cremation unless she adopts X. Here the adoption is voidable as having been induced by coercion. Then whenever any coercion is exercised while giving any consent, such an agreement is voidable. That means the person who has given his assent for the agreement, such person can show that he has been compelled to give the consent and he has been exercised coercion to give the consensus to such a contract. Moving to next factor, undue influence. So it says that contract is said to be induced by undue influence where the relations subsisting between the parties are such that one of the parties is in a position to dominate the will, and that dominant party uses to obtain an unfair advantage over the other. This is what the undue influence means. We can take an example to understand. A father, by reason of his authority over the son, can dominate the will of the son. Similarly, a doctor can use his dominant position to enforce the patient to execute any contract. Similarly, a trustee can also dominate the will of the beneficiary. So we can say there is such a position of the parties, one party dominates the other and lead to enter into a contract to obtain an unfair advantage. And the effect of such an contract is that the contract is voidable at the option of the parties whose consent was so obtained, and contract may be set aside. Now looking to the next factor, fraud. The term fraud means a false representation of facts made willfully with the view to deceive the other party. So these are the following statements, you can say, or the acts which may be considered as a fraud. Let's take an example. X sells to Y locally manufactured goods as imported goods, charging a higher price. It may amount to fraud. Because here you are suggesting to the person that these goods are the imported one, which is not true. And you knows the fact that it is the locally manufactured good, and you are saying this thing with an intent to charge the higher price. So this may amount to fraud. And the effects of fraud are whether you can resign the contract, or if you want, you may keep the contract as it is, and you may go for the performance of the contract. And along with the rescinding of the contract, you have got a right to claim the damages. Then misrepresentation.
Like fraud, misrepresentation is incorrect or false statement made innocently or non-disclosure of the material fact without any intention to deceive the other party. Misrepresentation is misstatement of facts by one which misleads the other, who consequently can avoid the contract. For example, X hears from A that Y would be the director of a company to be formed. X tells this to B in order to induce him to purchase shares of that company, and B does so. This is misrepresentation by X, though he believed in the truthness of the statement and there was no intent to deceive, as the information was derived not from Y but from A and was mere hearsay. Then the effect of representation is that the person can resign the contract and the person can insist upon performance. When both the parties to an agreement are under a mistake to a matter of fact essential to the agreement is altogether void. The court will enforce a voidable contract if not avoided, but will not recognize an agreement that is void. For example, A agrees to sell to B a specific cargo of goods supposed to be on its way from England to Bombay. It turns out that before the day of the bargain, the ship conveying the cargo had been cast away and the goods lost. Neither of the parties was aware of these facts. The agreement was void. Both the parties must be under mistake. Then, what is lawful object and consideration? Consideration or the object of an agreement is unlawful if it is forbidden by law, or if it defeats the provision of any law, or it is done through a fraudulent means, or it involves or implies injury to a person or property, or the consideration or object is immoral or opposed to public policy. An agreement will not be enforceable if its object or the consideration is unlawful, and the agreement will be void.
Now moving to the next slide, meaning of performance. Performance of the contract is one of the various modes of discharge of the contract. As per the Act, the parties to a contract must either perform or offer to perform their promises unless such performance is dispensed with, or excused under the provisions of the Contract Act or any of the other law. Such a contract is said to be performed. Then, what are the types of performance of contract? There are basically two types of the performance of the contract: actual performance and the attempted performance. In the case of actual performance of contract, when a promisor has made an offer of performance to promisee and the offer has been accepted by the promisee. It is called as actual performance of the contract. Example, X contracted Y to make a delivery of a car on Dhanteras at his residence. X brought the car to the residence of the Y on the day of the festival Dhanteras, and Y took the delivery of the car. This is an example of actual performance. Now, what is an attempted performance of the contract? Where a promisor has made an offer to the promisee and the offer has not been accepted by the promisee, it is called as attempted performance of the contract. Taking an example, X contracted Y to make a delivery of the car on Dhanteras at his residence. Here in this case, X brought the car to the residence, but Y refused to take the delivery of the car. This is a case of attempted performance because X has done what he was required to do under the contract. And the effect of the performance of the contract is that in the case of the actual performance of the contract, liability of the promisor comes to an end. Whereas in the case of attempted performance, the promisor is not responsible for non-performance and have a right to claim. Next, rule as to time and place for performance of the promise.
Now we will see that what are the cases when the time and place of performance of the promises are not specified or like that. That first case is that where the time has not been specified. Then in that agreement, the performance has to be done within the reasonable time. Second case is there where the time has been specified in the agreement in the contract, but promise is to be performed without promisee application. Then in this case, the performance has to be done during the usual business hours on that particular day. Where the time has been specified but promise is to be performed on promisee application, then in this case, the promisee must apply for the performance at a proper place and within usual business hours. Where the place is not specified, then there the promisor must apply to the promisee to appoint a reasonable place for performance and to perform the promise at such place. Then where the manner for performance has been prescribed, in that case, the promisee must be performed in the manner and at the time prescribed by the promisee. Section 56 contemplates various circumstances under which agreement may be void since it is impossible to carry it out. Where the agreement to do an act impossible in itself is void. A contract to do an act which, after the contract is made, becomes impossible or by reason of some event which the promisor could not prevent, unlawful, becomes void when the act becomes impossible or unlawful. The effects of impossibility of the performance of contract may be discussed under two heads: the effect of initial impossibility and effects of supervening impossibility, which we will discuss in the coming slides. Where an act becomes impossible after the contract is made, then what are the effects? Here, the contract becomes void when the act becomes impossible. Second, where an act becomes unlawful by reason of some event beyond the control of promisor, then the contract becomes void when the act becomes unlawful. Where the promisor alone knows about the impossibility, then the promisor must compensate the promisee for any loss which might have suffered on account of non-performance of the promise. Where an agreement is discovered to be void or where a contract becomes void, then any person who has received any benefit under such agreement or contract is bound to restore it or to make compensation to the person from whom he received it.
Now, let's see what are the modes of discharge of contract by mutual agreement. These are the following modes which may be taken into consideration by the parties to discharge the contract by mutual agreement. These are novation, rescission, alteration, remission, and the waiver. Novation means where the party may substitute a new contract for the old one. If they do so, it will be a case of novation. And on novation, the old contract is discharged and consequently it need not be performed. And in the case of rescission, a contract is also discharged by rescission where the parties to a contract agree to rescind it, the contract need not to be performed. In the case of alteration, the parties agree to alter the terms of the contract and the original contract is rescinded and with the result that it need not to be performed. And where the promisee waives or remit the performance of the contract, there is no need to perform the contract. These are all the modes whereby the parties under the mutual agreement, they may discharge the contract. We can take an example. A sells his horse to B with promises to pay rupees 500 for the horse. A may accept instead of rupees 500 a necklace at the price of the horse. So here you can see the parties may, with the stipulated performance, they may do any satisfaction which he thinks fit. So in place of the horse, they have negotiated with a necklace as the price of the horse. Discharge of a contract. Discharge by performance already discussed. Then discharge by mutual agreement as earlier discussed. Now discharge by impossibility of performance, that has also been discussed. Discharge by lapse of time. Wherever any time has been prescribed for the formation of the contract and within that time period no contract has been performed, the contract will be said to be discharged. Similarly, discharge by operation of law. A contract may be discharged by operation of law, which includes by death of the promisor or by insolvency extra. Then discharge by breach of contract. If one of the parties to a contract break the promise, the party injured thereby has not only a right of action for damages, but also he is discharged for performing his part of the contract. The next, breach of contract.
A breach of contract occurs if any party refuses or fails to perform his part of the contract or by his act makes it impossible to perform his obligation under the contract. In case of breach of contract, the aggrieved party is relieved from performing his obligation and gets a right to proceed against the party at fault. When the party declares his intention of not performing the contract before the performance is due, it is called as anticipatory breach of contract. In the case of anticipatory breach of contract, the aggrieved party can either resign the contract or can claim the damages without waiting, or he can treat the contract as operative and wait till the due date of performance and claim damages where still the promise remains unperformed. And what is actual breach of contract? It is a case of refusal to perform the promise on the scheduled date. But when one of the parties breaks the contract by refusing to perform his promise, he is said to have committed an actual breach of contract. Actual breach of contract may take place in any of the following two ways. On due date of performance, for example, X agreed to sell and deliver Y certain amount of wheat in 2 installments on 5th and 7th day of November. X refuses to deliver the goods on 5th of November. It is an actual breach of contract on due date of performance. And second actual breach of contract is during the course of performance. For example, X agreed to sell and deliver to Y certain amount of wheat in 2 installments on 5th and 7th of November. X delivered the 1 installment on 5th of November and refused to deliver remaining. It is an actual breach of contract during the course of performance. Then what are the liability for damages? Damages are the monetary compensation allowed for the loss suffered by the aggrieved party. Then here are the damages. Liability for special damages, liability to pay vindictive or exemplary damages, liability to pay nominal damages, and damages for deterioration caused by delay. Then the question arises then how to calculate the damages. The calculation is divided into 4 parts. Rescission of contract, suit upon quantum merit, suit for specific performance, and suit for injunction. These we are discussing in the detail in the coming slides.
Now, taking first of the matter, how the damages are being calculated is the rescission of a contract. So when the contract is broken by one party, the other party may treat the contract as rescinded. In such a case, he is absolved of all his obligation under the contract and is entitled to compensation for any damages that he might have suffered from non-performance of the contract. For example, X agrees to supply 100 canes of ghee to Y on 1st of November on the occasion of Diwali. Y promises to pay for the supply in his receipts. X does not supply the good on the due date. Here Y is discharged from the liability of paying the price. Y is entitled to rescind the contract and claim compensation for the damage which he has sustained because of the non-supply of the goods on the due date. Suits upon quantum merit. The phrase quantum merit means as much as is earned or according to the quantity of the work done. When a person has begun the work and before he could complete it, the other party terminates the contract or does something which makes it impossible for the other party to complete the contract, he can claim for the work done under the contract. We can understand this concept with an example that C, an owner of a magazine, engaged P to write a book to be published by installments in his magazine. After few installments were published, the publication of the magazine was stopped. It was held that P, the publisher, could claim payment for the part already published. Suit for specific performance. Where damages are not an adequate remedy. In the case of breach of contract, the court may, at its discretion on a suit for specific performance, direct party in breach to carry out his promise according to the terms of the contract. Example, X agreed to sell an old painting to Y for rupees 1000. Subsequently, X refused to sell the painting. Here, Y may file a suit against X for the specific performance of the contract. There are certain examples where the specific performance are not maintainable, where the damages are an adequate remedy, or where the contract is of a personal nature, or where contract is made by a company beyond its power, or where one of the parties is minor. In these situations, the suit for specific performance is exempted and is not maintainable. The suit for injunctions. It means demanding court's order to prohibit on the doing of something. In a layman's language, the suit for injunction is known as stay order. Example, A agreed to sing at B theatre only during the contract period. During the contract period, A made contract with Z to sing at another theatre and refused to perform the contract with B. It was held that A could be restrained by injunction from singing for Z. Now taking the special types of the contracts.
A contract may be absolute or contingent. An absolute contract is one where the promisor undertakes to perform the contract in any event without any conditions. Section 31 of the Act defines contingent contract as a contract to do or not to do something if some event collateral to such contract does or does not happen. Contract of insurance, indemnity, and guarantee fall under this category. This contract has been dealt from Section 31 to 36 of the Indian Contract Act 1872, which consists of definition and rules as enforcement of the contract. What do you mean by collateral event? Collateral event as an event which is neither a performance directly promised as part of the contract nor the whole of the consideration for a promise. For instance, if A contracts to pay B rupees 1 lakh if B's house is destroyed by fire, then it is a contingent contract. Here the burning of the B's house is neither a performance promised as part of the contract nor it is the consideration obtained from B. The liability of A arises only on the happening of the collateral event, that is, destroyal of the house by fire. In order to judge that the contract is the contingent contract, there are three essential elements which must be present: dependence of the future event, collateral event, and the uncertain event. For example, A promises to pay B certain amount if particular ship does not return within a year. The performance of a contingent contract to pay certain amount is made dependent upon the non-happening of an event. If certain ship does not return within the year, that is dependent on the future event. The second essential element features of a contingent contract is collateral event. The event on which the performance is made to depend is an event collateral to the contract. For example, where A promises to pay B rupees 1 lakh if he marries C, it is not a contingent contract as there is no collateral event on which performance of contract depends. The third essential feature of a contingent contract is uncertain event. The contingent event should not be the mere will of the promisor, rather the event must be uncertain. For example, if A promises to pay B rupees 10,000 if A left Delhi for Mumbai on a particular date, it is a contingent contract because going to Mumbai is an event no doubt within A will, but is not merely his will. Then there are various rules regarding contingent contracts. These rules are relating to enforcement of a contingent contract are laid down in section 32, 33, 34 and 36 of the Act. The students can read them in detail. The various rules regarding the enforcement of contingent contract are as follows. Enforcement of contract contingent on the event happening. Where a contract is made to do or not to do anything if an uncertain future event happens. For example, X enters into a contract to buy Y's car provided Y survives A. Here Y surviving A or A dying before Y is the event on which the contract is contingent and they cannot be enforced until A dies. The second rule regarding contingent contract is enforcement of contract contingent to an event not happening. Where a contingent contract is made to do or not to do anything, if an uncertain future event does not happen, it can be enforced only when the happening of that event becomes impossible and not before. For example, A agrees to pay sum of money to B. If certain ship does not return, however, the ship returns back. Here the contract becomes void.
Moving to the next rule, contract contingent to be upon the future conduct of a living person. So such type of contracts becomes void if before the expiry if you see this rules deals with the section 34 of the Indian Contract Act. It says that if a contract is contingent upon as to how a person will act at an unspecified time, the event shall be considered to have become impossible when such person does anything which renders it impossible that he should so act within any definite time or otherwise then under further contingencies. We can understand this rule with an example where A agrees to pay B a sum of money if A marries C. However, C marries D. This act of C has rendered the event of A marrying C as impossible, though it is possible if there is a divorce between C and D. Next rule, contract contingent upon the happening of an uncertain specified event within a fixed time. Such type of contracts become void if before the expiry of the fixed time, such event does not happen or such event becomes impossible. For example, X promises to pay P a sum of money if certain ships return within a year. Here the contract may be enforced if the ship returns within a year, that is within a fixed time, and becomes void if the ships return within the year. Since we are in this example, we are talking about the happening of any uncertain event, but it has become impossible due to any circumstances or event does not happen, that may lead to the void. Next rule, contracts contingent upon the non-happening of an uncertain specified event within the fixed time. We can understand this concept with an example. Earlier we have dealt with the happening of an uncertain event within the fixed time. This is dealing with the non-happening of an uncertain event within a fixed time. X promises to pay Y a sum of money if certain ships does not return within a year. Here the contract may be enforced if the ship does not return within the year or is burnt within a year. Since the ship has not returned, there is a non-happening of the specified event, so it is enforceable. Moving to next rule, agreement contingent on impossible event. A contingent agreement to do or not to do anything if an impossible event happen is void. For example, if X agrees to pay Y 1,000 rupees if two straight lines should enclose a space, this agreement is void. Then moving to next special type of the contract, that is the quasi contract.
In the case of every contract, the promisor voluntarily undertakes an obligation in favor of the promisee. A similar obligation may be imposed by law upon a person for the benefit of another, even in the absence of a contract. Such cases are known as quasi-contracts. Quasi-contracts are based on principles of equity, justice, and good conscience. The salient features of quasi-contractual rights are as follows. It does not arise from any agreement of the parties concerned, but is imposed by the law. Secondly, it is a right which is available not against the entire world but against a particular person or persons only. And obligation is a duty and not the promise of a party. Right is available against specific person. The right is always a right to money, and the person can sue for breach may be filed same as of a complete contract. A quasi or constructive contract rests upon the maxims no man must grow rich out of the another person loss. For example, P supplies milk to his customer R, who receives and consumes it. R is bound to pay the price. R acceptance of the milk constitutes an implied promise to pay. These relations are called as a quasi-contractual obligations. Now we will see the difference between the quasi-contracts and contracts. That on the basis of essential for the valid contract, the essential for the formation of a valid contract are absent in the case of quasi-contracts, and in the case of contract, the essentials for the formation of valid contract are present. Next is obligation. The obligation in the case of quasi-contract is imposed by law, but in the case of contract, it is created by the consent of the parties, which we have discussed earlier in our slides. Now we will see that types of quasi-contracts. Claim for necessaries supplied to the persons incapable of contracting, right to recover money paid for another person, obligation of a person enjoying benefits for non-gratuitous act, responsibility of a finder of goods, liability for money paid or things delivered by mistake or under coercion.
Now let's take these types of quasi-contracts in details. The first one is claim for necessary supply to person incapable of contracting. This has been dealt under section 68 of the Indian Contract Act. If necessaries are supplied to persons who is incapable of contracting, for example, a minor or a person of unsound mind, there the supplier is entitled to claim their price from the property of such persons. Next step of the quasi-contract, right to recover money paid for another person. So it is said that a person who has paid a sum of money which another is obliged to pay is entitled to be reimbursed by that other person, provided the payment has been made by him to protect his own interest. Whereas the other kind of quasi-contract is with respect to the finder of goods. A person who finds goods belonging to another and takes them into his custody is subject to the same responsibility as that of a valet. This we can understand by an example. Mr. X found a golden ring at a birthday party of Y. X informed of this to the Y. He has performed his duty to find the owner. If he is not able to trace the owner, he can retain the ring as a valet. Liability for money paid or things delivered by mistake or under coercion. So section 72 says that a person to whom the money has been paid or anything delivered by mistake or under coercion must repay or return it. For example, if A and B jointly gave 500 rupees to C, A alone pays the amount to C and B was not aware of this fact and pays rupees 500 again to C. Here C is bound to repay the amount to A as already the payment has been done by A. Then what are the remedies available on the breach of the quasi-contract? So it says that in the case of breach of contract, there the injured party is entitled for the compensation same as that of the defaulted party has broken his contract in the same manner as that of a normal contract. Then contract of indemnity and guarantee. These are again the special type of the contracts.
It is covered under section 124 and 147 of the Indian 147 of the Indian Contract Act. Indemnity. There are two parties in this form of contract. The party who promises to indemnify the other party from loss is known as indemnifier, whereas the party who is promised to be saved against the loss is known as indemnified. For example, X, a shareholder of a company, lost his share certificate. He applied for the duplicate. The company agreed to issue the same on the term that X will compensate the company against the loss, where any holder produces the original certificate. Here, there is a contract of indemnity between X and the company. And now we will see that what is guarantee. There are three parties in a contract of guarantee. Surety, person who gives the guarantee. Second, principal debtor, the person in respect of whose default the guarantee is given. And third, the creditor, the person to whom the guarantee is given. For example, where A obtains housing loan from LIC Housing, and if B promises to pay LIC Housing in the event of A failing to repay, it is a contract of guarantee. What constitutes consideration in a case of guarantee? Section 127 of the Act specifies that anything done or any promise made for the benefit of the principal debtor may be sufficient consideration to the surety for giving the guarantee. Then what is the surety's liability in the case of contract of guarantee? Section 128 specifies the liability of the surety is coextensive with that of the principal debtor. The liability of the surety is same as that of a principal debtor, where a debtor cannot be held liable on the account of any defect in the document. The liability of the surety also ceases. Surety's liability continues even if the principal debtor has not sued or is committed from being sued.
Now moving to the continuing guarantee given under section 129 of the Contract Act. So it has been explained as a guarantee which extends to a series of transactions. To a series of transactions is called as a continuing guarantee. And when the liability of surety comes to an end, so it says it continues till the performance of the contract or the discharge of all the transactions entered into or when the guarantee is withdrawn. However, the continuing guarantee may be revoked at any time by the surety or upon the death of the surety. So let's take an example where A promises B to be responsible so long B employs only C to collect his rental from tenants for an amount of 5,000 rupees. There is a continuing guarantee by A to B so long C is employed as a rent collector. In other words, we can say that A stands as a guarantor to B for rent collected by C. Then discharge of surety. Section 133 to 139 of the Act lays down the law with respect to surety when they would be discharged. So these are the various conditions under which the surety may be discharged. Let's take an example to understand these. Where A stands to C as a surety for B for rent payable by B to C for C's house. And if B and C agrees on a higher rent without A's consent, here A would stand discharged for the entire rent amount accruing after the date of variance. We can take another example. A puts M as a cashier under B and agrees to stand as a surety provided B checks the cash every month. B embezzles the cash. A was not held to be responsible as B failed to verify the cash every month. Then when guarantee is invalid, if the guarantee is affected by any of these three factors, the guarantee will be said to be an invalid. Then differences. As already discussed, in the case of indemnity, there are two parties, indemnifier and the indemnified, whereas in the case of the contract of guarantee, there are three parties. The liability of in the case of indemnity, the liability of the promisor or indemnifier is primary and is independent. where in the case of guarantee you will find that the liability of surety is secondary and the primary liability is that of the principal debtor with the creditor. Then next, the liability of the indemnifier arises only on the contingency. That is, if the indemnified has made any default. Whereas in case of a guarantee, the liability already exists in existence but crystallizes or come into enforcement when the principal debtor fails to perform his part of the contract. Then further, indemnifier cannot sue a third party for loss in his own name since there is a privity of contract. Whereas in the case of the surety, in the case of guarantee, surety may proceed against the principal debtor because he gets all the right of the creditor. He steps in the shoes of the creditor after discharging the debts. Then with respect to the bailment,
What is the meaning of term bailment? It is covered under Section 148 of the Indian Contract Act. Bailment means handing over or change of possession. As per Section 148, bailment is an act whereby goods are delivered by one person to another for some purpose on a contract, that the goods shall, when the purpose is accomplished, be returned or otherwise disposed of according to the directions of the person delivering them. The person who delivers the goods is the bailer, and the person to whom the goods are delivered is the bailee. For example, where X delivers his car for repair to Y, X is the bailer and Y is the bailee. The essential characteristics of bailment are that bailment is based upon a contract. Sometimes it could be implied by law, as it happens in the case of finder of lost goods. Bailment is only for movable goods and never for immovable goods or money. In bailment, possession of goods changes. Change of possession can happen by physical delivery or by any action which has the effect of placing the goods in the possession of bailee. In bailment, bailer continues to be the owner of the goods as there is no change of ownership. Bailee is obliged to return the goods physically to the bailer. The bailee cannot deliver some other goods, even not those of higher value. Then these are the duties of the bailer. Then he shall disclose known facts. He should bear the necessary expenses, indemnify bailee, and bound to accept the goods. These are the rights of the bailer. That the bailer has a right to enforce the duties of the bailee. He has the right to terminate the contract. He has a right to demand the goods back. He has a right to claim the increased profits. The duties of bailee. The bailee should take care of goods bailed. Then he should not use unauthorized use of goods. Then he should not mix the bailer's good with his own, and he shall return the goods to the bailer. The bailee must compensate to the bailer for loss arising from non-disclosure of defects. He can claim of indemnification for loss, damage due to defective title. The bailee has the right to return the goods, and bailee's right has a right to lien. The contract of bailment can be terminated on the basis of any act done inconsistent with the condition of bailment. If the period of bailment expires, then the bailment is terminated. The demand for return of goods, and if any bailer or bailee dies.
here are the different terminologies which differ from the terms of the bailment. In the sale, we just transfer the right of the ownership to the person. And in the case of bailment already discussed, there is only the change of the possession. Where in case of hire purchase agreement, you will find that the ownership is transferred after the last payment of the installment, and this is being regulated by the hire purchase agreement. And the contract of work and labor, there is no sale of the good, but certain labor or the work has been done on it. For example, if we supply any gold to the goldsmith for formation of an instrument, it will be considered as a contract of work and labor. And the license License is you can say it is a permit from an authority to own or use something to do particular thing. Whereas the third last terminology is pledge. Pledge is a species, you can say it's a species of the bailment, and this will be taken in detail in our next coming slides. Pledge is a variety of or species of bailment. In pledge, there is no change in the ownership of the property. However, the section 170 to 182 of the Indian Contract Act deals specifically with the bailment of the pledge. For example, A lends a money to B in lieu of a jewelry deposited by B as a security to A. So this bailment of jewelry is a pledge as a security for lending the money. B is the pawner and A is the pawnee. That means there are two parties. The person who pledges or bails the goods is a pledger, whereas the person to whom the good has been pledged is the pawner. So since here the bailment of good is done as a security for the performance of a promise, this is known as a pledge. And in the example we said that the person lends some money in lieu of the jewelry deposited as a security. So this is the pledge. Now essentials of a contract of pledge. That there must be a bailment for security as already discussed in the definition of the pledge. Then goods must be the subject matter of the contract. Then good pledge must be in existence, and there must be a delivery of goods. That means the possession has been shifted to the pawnee. Then how you can distinguish between a pledge and a bailment? Goods are bailed as a security for loan in the case of a pledge, whereas in the bailment, the goods are being bailed for the own purpose. For example, if I give you a pen for writing or doing a sign on a certain paper, this is a bailment. But if I give something to you as a security for the performance of a contract or a promise, then that is a pledge. And in the pledge, the pledgee has a right to use the goods. Where in the bailment, you can say he can do so, but if the terms of the contract provide so. In the pledge, there is always a consideration, but in the bailment, it may or may not. On the payment of the debt or the performance of the promise, the contract is discharged under the pledge, whereas in the case of the bailment, as the purpose is accomplished or after the specified time, the contract of bailment may be discharged. Now, the agency. Agency is a relation between an agent and his principal created by an express or implied agreement, authorizing an agent by his principal to create contractual relations with third parties. So, person so appointed to represent the principal is called the agent, whereas the person who appoints an agent to represent him as per his directions and authority is called the principal. There are certain silent features of this agency. First, on the basis of the basic essence you can say of the agency is that the principal is bound by the act of the agent, and so he is answerable to the third parties. And unlike other regular contracts, the contract of agency does not need consideration, and the person who is competent to contract alone can employ an agent. And a person, in order to be an agent, must have authority to contract. So a minor can be appointed as an agent, though he has no capacity to contract, but may have authority to act as an agent. What are the modes of creation of agency? So it is said that agency may be created by actual authority, and it can be express or implied. Then agency can be created by ratification. So here agency needs to be created by subsequent ratification or approach. Sometimes what happens, the agent acts without the knowledge or approval of the principal, and therefore they require the subsequent ratifications. So agency can be formed by the ratification. Then agency by ostensible authority. Where the authority of the principal is inferred by the conduct of the principal, the agency through ostensible authority is formed. So here the agent's authority is ostensible and the principal is bound to act by the agent. So this is the ostensible authority, whereas agency may also be created by a necessity. Then how the termination of the agency take place? it says that under section 201 of the Act, there are certain circumstances where the authority conferred on the agent gets terminated. So these are whether there is a revocation of authority by the principal, or renunciation of agency, or either the business for which the agency has been made has been completed, or there is a death of the principal or the agent, or due to the insolvency of the principal, the termination of agency may be. So with this, we would like to end our session, and it's an immense pleasure to share you through these dives or through this platform the various issues related to your academics, your examinations, your preparation and all that. So in case of any further query, you can mail us at nisha.gupta, nisha.gupta@ICI.in, whereas you can also mail your queries at Megha, megha@ICI.in. And with this, we would like to conclude our session and wish you all the best, and thank you.